Now that we have a quorum present, we'll call the meeting to order. Can we have a volunteer to do the minutes for this evening? Catherine, can I tap you to do the minutes?
Not hear me?
I am.
Okay. Yes, you can.
Okay, thank you. And part of this is just spreading the wealth around. So meeting called to order at 7:02. Welcome everyone to yet another installment of bylaw review meeting number 15,742, or so it seems, where we get to review lots of bylaws. We've got a few administrative items to go over, and then we will jump right into the bylaws themselves. So great to see most of you on Saturday. Did appreciate seeing you there for the town meeting. We had a very interesting discussion, and it was an interesting time for those of you who were there to see how all of that worked. Where we did have a very thoughtful and thorough discussion on bylaws. That was the most substantive discussion that I've seen in quite a while on bylaws at the actual town meeting itself. So with that, the first item we have is public engagement. We have a few members of the public. If anyone would like to speak at this time, you're welcome to do so. Otherwise, you're also welcome to contribute during the substantive parts of the conversation as well. Seeing none,
I'm sorry. Will you
Go
be
ahead.
taking suggestions, questions during each section? Is that how you're?
Yes, we take it and try to make it as informal as we can get away with, as long as the process is collaborative. Then we're happy to take it in line. That way, the questions and dialogue gets to be interactive.
Great, thank you.
Absolutely. Next item on the agenda itself is the minutes from November 6th. Tim, thank you very much for doing a good job of taking very thorough minutes. For that, these were put into the Dropbox folder. The one change that, just as we get started for this, I just wanted to note is the note for a roll call vote on item 3. There was a note that it was actually approved. It just didn't specify that that was roll call. It did make it clear as to who voted. It just in the affirmative, it just did not specify roll call. So that just is minor administrative change. So with that, do we have a motion to approve the minutes with administrative changes for compliance as noted?
So moved.
Okay, Joe has made the motion to approve the minutes as presented with administrative changes. Lucy has seconded. Catherine is typing away, making sure that we've got everything recorded. Any other input, any other feedback on the minutes themselves? Otherwise, with much thanks, Tim, I thought you did a good job of capturing the discussion of the meeting itself and going over different items and making notes as required for what is needed with the minutes themselves. So with that, we've got a motion to approve the minutes with the minor administrative detail of adding the roll call vote for item number 3. Though the other vote that was taken to adjourn, it was noted as it was done by roll call. This is a requirement for all remote meetings, so that's the reason why we have to designate that. If it's an in-person meeting, you don't have to, but for remote meetings, that designation is still required. So with that, we have motion to approve. It's been seconded. No further discussion. So with that, we will vote in the order in which people appear on my screen. Joe?
Yes.
Tim?
Yes.
Kevin?
Yes.
Catherine?
Yes.
Lucy?
Yes.
And Eric, if you wish to participate, we're just voting on the minutes for November 6th with minor addition of just specifying the item number 3 was done by roll call.
I'll vote present.
Okay, and Eric is voting present. I'm voting in the affirmative. So with that, we've got the motion passes. Minutes are approved. That brings us over to the substantive part of the meeting itself, reviewing the zoning bylaws. So these have all been posted to the town's website for the bylaw review committee so that people can actually see the information as well. The only one that wasn't posted specifically was 190, 111, the cannabis moratorium. And the reason that it wasn't posted was to be pretty direct about it was I believe the recommendation was to remove it in its entirety.
correct.
So Attorney Bobrowski, if you just want to, that's first item on the agenda itself. You just want to explain. That's the reason why I didn't post it, because it looked like your recommendation was to just have that pulled in its entirety.
Yep, that's exactly right, Mr. Chairman. Do you allow cannabis shops in town?
I don't believe we have any at the moment, and I'm not aware. I know that that there was the attempted moratorium and that was rejected, and then we have this version, which I believe was accepted, but I don't believe we currently have any since the state law permitted them explicitly.
Was Wakefield a yes or a no vote?
For permitting,
Yeah,
it was a yes vote for permitting the state for the state law. It was a no. It was a moratorium as well.
yeah.
It was the test case for the moratorium.
Okay.
Joe,
Well,
Joe, being on ZBA, is that consistent with your understanding as well?
I'll be honest with you, I don't remember.
Okay.
I don't remember where we stand on it.
And
well,
Theo, you're on planning board. Are you aware of anything that permits cannabis?
No, I think we're still under the moratorium.
Okay.
I'm gonna
Just-
look it up right now.
Just to give you a bit of background, Attorney Bobrowski.
okay, I'm looking through my strike through here. It looks to me like the moratorium was adopted after the 2016 referendum. And reading through the strike throughs, the purpose of the temporary moratorium is to provide the town time to study, reflect, and decide concerning the state regulations for both medical and adult recreational marijuana. You certainly had all that time. And the moratorium shall be in effect through June 30th, 2018. So we're 5 years past that. This one probably wouldn't be valid because your purpose that was announced, time to study the state regulations, has long overdue for you to have finished that job. Moratoria are fairly uncommon. A lot of towns have put moratoria in place for apartment buildings, but I think Arlington's probably the lead case on that. It's okay to do that, but it has to end at some point. It can't go on, or it's not a moratorium, it's a permanent ban. So I believe in the Kalura case from Arlington on apartments, the moratorium was for 18 months, and that was upheld by the Supreme Judicial Court. But I think you're long past due here. So my recommendation would be to get rid of it. Now, if you are going to actively entertain at this point applications for recreational use or even medical use, you probably ought to think about adopting 2 bylaws, one for RMDs, registered marijuana dispensaries, that's the medical side, and the other one for recreational marijuana. And there are many good models out there. So right now, with the moratorium having expired, and with you having no regulations in place that specifically address cannabis, you are subject to an application for a retail operation. After all, the bylaw does allow retail. And since it doesn't specify anything about retail, cannabis, it's going to be treated like just another retail operation for the purposes of the law. That's what happened in a small town that I'm land use council in Berkeley. They voted yes, like you. They did not adopt regulations, and I sat with the board while we approved at least one store and at least one manufacturing process, grow manufacturing and processing operation, all under agriculture because it's agriculture.
So if there is a desire to have additional controls for, what would you recommend?
I can show you a state-of-the-art medical marijuana bylaw, and I can show you a state-of-the-art adult bylaw, recreational bylaw, and you would put it on the warrant for the next for the town meeting with the recodification. And I'd probably call it out. That's a very controversial article. I'd probably put it as a separate article after the main article, so that it doesn't bog the main article down.
Okay.
So I'll make a note.
If you can prepare that, I don't know what direction either the town administration would want to take on it, but I think having the language could be beneficial for at least consideration.
Yeah, many times these recodifications result in banked warrant articles, and when the time is right, if it wasn't right when we were doing the recodification, it might be later. And that's happened on a number of different subjects, including solar, and that's eventually something we'll have to talk about on that as well.
That, for what it's worth, energy was the main topic at the town meeting that we just had on Saturday. We had approximately a 2.5-hour discussion about different energy pieces. The town just adopted the specialized energy code. So the solar is definitely something that is being strongly encouraged across town.
Yeah, and it's an interesting topic because, not to get off the subject, but because right now the state courts are in disarray with regard to the subject of solar. That's because the legislature, in its infinite wisdom, did not use the same language for solar energy systems as they used for churches, schools, and childcare facilities. It's very different language. So it's easy to regulate churches, schools, and childcare facilities because under the Dover Amendment, we all understand the rules. But the solar energy language is different. The land court has ruled that it's the same in substance as protection for churches and schools and childcare centers, which is you can't stop it in any district, and you can't put it on special permit either. And there's only one case from a high court. It was from Waltham a couple of years ago. Waltham allowed solar only in its industrial district, and that constituted 2% of Waltham. In particular, they only allowed large-scale ground-mounted solar in the industrial district. And the solar company sued, saying that's not allowable under the statute, and they won. But it didn't teach us anything other than you can't just have 2% of your city in available for large-scale ground-mounted. Many towns have regulations that ban solar in typically the R80 district, because that's where the people with the most money live, and they don't want to look at solar. So they've banded together a town meeting to stop it. And we don't know anything about whether that's legal or not, because there's never been a case at the appellate level. Judge Piper, the Chief Justice of the Land Court, had a case from Southern Worcester County, and he basically came right out and said, this is just like a church, a school, or a child care facility. And that's a standalone case. So, and it's a land court case. It's not an appeals court or a Supreme Judicial Court case. So there's a lot of news in that front yet to come. And hopefully if you're going to regulate solar, we'll get some guidance here before the town meeting.
Okay.
All right, so I've made a note to prepare those bylaws and get them to you.
Okay. Other thoughts on cannabis? Mr. McGrail.
Well, thank you, Mr. Chair. I just want to point out, I don't know a lot about it, but Mark, just when you're doing this, we did amend our bylaw twice, and once was in 2014, where we now allow what's called a registered marijuana dispensary in the limited industrial district with a special permit.
Yeah, that's the medical.
Okay, but it's not defined. And then we also, in our use table, have marijuana establishments as defined in Mass General Laws 94G, Section 1, whatever that is. That went in 2017, Mark, but it's all no's. It's not allowed in any district.
So that's the adult.
Okay, just so you know, they're there.
Yeah.
That's all.
Thank you. Thanks for calling that out. So you really kind of do need regulations, even if you're just going to stick with medical. And most of the regulatory stuff is what you'd expect. It's that you don't want odor. Marijuana grow facilities stink. So you don't want that odor dribbling outside the building, and there has to be a ventilating system that pretty much treats that. And you also want security. Those are the two big things. And there's all kinds of rules that you can put in place with regard to security. And it's important to have those if you are allowing RMDs in the industrial district. And I can, again, that's the typical bylaw. It has more parts, obviously, but those are the two big questions about marijuana, particularly grow. I had a facility in front of my planning board in Charlton, 1 million feet of grow. It was 850,000 square feet of grow and 150,000 of manufacturing and processing. And that thing had ventilators that would, treat the Empire State Building.
So if you can get us language on that, then we'll be able to have that discussion and also get input from others in the town as well.
All right.
The idea of having it as a separate article likely makes a lot of sense, because I have no idea what direction the townspeople would want to take on it at a town meeting itself. This is where the town meeting here can be unpredictable.
Yeah. And I think this is one that we want to handle with kid gloves. So.
Yep. And separately.
Okay. All right. So I'm gonna
moving along. Let's go on to performance standards.
That's going to be a major discussion. So what I'd like to do is the budget at town meeting. I'm going to move through what I consider to be the easiest ones, which would be OSD, trailers, the municipal business building reuse overlay district, the creative, and the accessory. And then that leaves behind adult, parking, and affordability. And then the performance stuff is all brand new. So I want to leave plenty of time to talk about that in great detail. Okay. So I'm going to race down to OSD next. I'm looking at my screen. So if I look a little distracted here, it's just because I'm looking at my own bylaw on my computer.
Okay, here's the open space development.
Yeah, so this is a nice bylaw. It doesn't have a whole lot. I crossed out to protect the value of real property. When you say protect the value of real property, you're creating a local interest in the prevention of diminished property values. Otherwise, the courts have held, and I'm talking about the Supreme Judicial Court has held, that this issue, protection of property value, is not protected by zoning unless the municipality indicates in the bylaw that they're creating a special interest here. And the reason it's so important, it has to do with standing. So if I'm doing an open space development and you're my neighbor and you're going to argue that I didn't deserve a special permit because it's going to devalue your property, unless the bylaw creates that as a local interest, and even in some cases, if it attempts to do so, you don't have standing. You have to, you can make a complaint that you're going to lose property value, but the courts have said that you have to tether that, their words, not mine, to a zoning related injury. And zoning related injuries are really predictable. It's traffic noise, odor, lights, stormwater. Those are zoning related injuries. And so if I can say that there's so much traffic, my property is going to go down in value, or there's so much noise that my property is going to go down in value, that's fine. But I can't just say my property is going to go down in value. That's not good enough for standing. And this is a really crucial issue in terms of litigation, because if somebody can just get a broker to say my property is going to go down in value, that's too easy for the court. The lead case is a Chatham case, and Chatham actually had this language in their bylaw, and the SJC ran right past it and said, you still have to tether, even if the local bylaw creates or attempts to create an interest. And I just argued this at the appeals court within the last 6 weeks in a case from Watertown, which has the same thing in their bylaw. So the plaintiff, I represent a gentleman in Watertown with an 85,000 square foot R&D facility, special permit. The neighbor sued. His chief argument is my property value is going to go down, not because of anything else, just because people don't like to live next to R&D laboratories. And I argued in the Superior Court, that's not standing, and I won. And now he's followed it up with an appeal in the appeals court. So it's just something to think about. I don't, there's so many things that are approved are sued, and this, it makes it too easy to sue them.
Thoughts from the committee or public?
Are you gonna go through the entire,
Yeah, I'm scrolling
Okay.
through it. I'm scrolling through it just to see what significant changes I made. I think I just added a sentence in 8.3.10. And this looks pretty much like the extent of my commentary. This is a model that I've used in many places. This language that you've got about steps 1 through 6 is very customary language. I can tell you where that started. It started with Bob Mitchell in Amherst about 35 years ago. He only had 5 steps. You've got 6, but this is basically the same thing that Bob Mitchell invented in Amherst 35, 40 years ago. Bob Mitchell's just recently retired from the planning business, but he's still around.
And
So
just to be clear, it's a different Bob Mitchell than the one that lives in town. We have a Bob Mitchell who's active in zoning issues within Wakefield. So that would be a different Bob Mitchell.
Yeah, no, Bob's from the Valley. So the rest of it is looks pretty solid to me. I made another cross out here in just a language change in 8.3.16. It's
so real quick on 8.3.10.
Yeah.
Or the item that you added, check the planning board rules, regulations for applicable fees and distribution of application materials. Does that give the planning board the ability to change those fees and on their own without having to go back to town meeting?
Absolutely. And you'll recall that one of the first comments I had in section 1, which I gave you when we were doing the original diagnostic, I'm sorry, when we were doing the, when we were doing everybody's job description, was to take the fees out of the bylaw and to make them just in planning board rules and regulations. And there are good examples of planning board rules and regulations from your neighbors. Lexington probably has the best planning board rules and regulations that I know of.
So Theo, who's on, we have a couple of members of the planning board here. So Theo, are there planning board rules and regulations that are formally adopted and published? Are you aware of them?
Yes, we have subdivision control rules and regs. We don't have street name rules and regs. I think the no, that's it, the subdivision control.
That's not the kind of planning board rules and regulations that I'm speaking about. These are rules and regulations that would administer your procedures for granting special permits, for assessing a site plan application. You might even have regulations in there for doing site visits or pre-application meetings, and then fees. Those would be the typical topics.
Yeah.
And like I said, I can, if you just Google Lexington Planning Board Rules and
Yeah.
Regulations, it'll pop right up on Google as your first thing.
Yeah.
I worked with Lexington 6 or 7, 8 years ago, and I did all their regs from the zoning to the subdivision to the planning board rules and regulations. It's good to have, because a lot of good stuff can be put into the planning board rules and regulations that you don't have to go through town meeting to do.
Yeah.
Town meeting gets into absurd fights about architecture and design, but planning board can decide those matters for itself and just put them in the rules and regulations.
That's a great advice.
Yeah, I remember reading Newburyport's site plan review objectives, and because they've got so much Greek revival, I could imagine a floor fight in Newburyport on whether or not we really still like Greek revival. So they just put it all in their regulations.
So it sounds like something that the planning board may wish to take up, for those of you who are on the planning board, is to get formal codification of rules and regulations. And those would those have effect on the Board of Appeals as well?
Board of Appeals can do the same thing, and many boards of appeals have adopted, and I'm sure yours is probably one of them, have adopted comprehensive permit rules and regulations for the administration of a comp permit. But you can do the same thing for the jurisdictional matters that are in the ZBA wheelhouse. That would be appeals from administrative decisions by the building inspector, special permits, because you can have ZBA as a special permit granting authority, and variances. And here's what you submit. Here's what the fees are.
Joe, are you aware if the ZBA currently has formal rules and regulations in that way?
I have to look that up. I know there's fees, but
And part of what I'm looking at here is that it may be this may be an expansion of the project outside of what this particular body is responsible for. So there may be more work for you, Mark. But there
Well,
may
that's what happened in Lexington, Dan. That's exactly what happened.
this could be a good way to move some of the codification to the relevant bodies, so that there's more control at a more appropriate level.
Yeah,
And
it's all part and parcel of a basic administrative law principle called delegation doctrine. So as long as the bylaw says that the planning board may make rules and regulations in order to administer site plan approval, there's the clear delegation by 2/3 of the voter at town meeting, much like the federal government, Congress, does the same thing to its agencies. And then the agency, to quote the federal case law, fills in the blanks. And that's all been accepted since the early 1900s as a basic principle of administrative law.
So for those members of the public, I know that you also have interest in zoning. Is there any opinions that you have on increasing the delegation in that way, just so we can gather input? To make sure, and by part of that is to make sure that it's also available publicly, so that people know what those rules and regulations are.
You obviously have to adopt them at a regular meeting, but you don't have to have a public hearing. You have to just post it as an agenda item. Nor do they have to be approved by the Attorney General, because they're not bylaws, they're just rules and regulations. Subdivision regulations have to have a public hearing.
So, Mr. McGrail?
Yeah, I just want to point out, I think that the planning board, and Theo wouldn't know this because it was well before his time on the board, has site plan review regulations. They never, I can't remember the last time the planning board had a site plan review in front of them, because under our bylaw, it's done by the zoning board in conjunction with the special permit. So it's very rare that that happens at the planning board, but I think if you go back, Theo, or I might even have a copy, I could share them with you, because I think that I think, and again, think they actually exist, but very rarely used. I remember, I think it was Paul Donaco when he was on the planning board and, you know, led the charge on getting them enacted. And Paul Rivas had them at the time when he was town planner. So I'm happy to look to see if I can find them.
That,
and-
that would be delightful, but, yeah,
If not, anyways, they're probably antiquated because, you know,
Yeah.
you want to look at them anyways, but it might be a start or something for Mark to look at if he's gonna look.
Well, let me suggest, do we have both the planning board chair and the ZBA chair here?
We don't have the ZBA chair, but we do have a member of ZBA.
Well, let me give you both of you my email, and if you'll just send me an email when the meeting's over tonight, I'll go online and dig out the Lexington stuff I'd like you to look at, and I'm sure I can do the same thing with regard to ZBA stuff. And I'll
Sure.
send them respectively to the both of you. So my email is Mark with a K at BBHS, that's boy, Harry, Sam, law, LAW.net.
score.
It'll give you some reading for Turkey Day.
Love it.
Thank you.
Okay. So I don't think that the
That's great.
the OSD just obviously has not changed that much, and I made a couple of cosmetic changes. Please don't get distracted by the 3 asterisks that I have next to certain numbers in there. That's a placeholder for me because I don't know where everything's going to end up. I come back and fix it all at the end. All right, so I'm going to look at trailers next, which is
So
really
before we move on, one thing that I did notice is in 8.3.15, there's
Mhm.
some references in this bylaw to Wakefield Master Plan of 2003. And I know that when the Wakefield Master Plan, there's currently a process under which that will likely get updated. Will that need to then have the bylaw re-reviewed?
No, but what I'll do is I'll put in here or later
Or a successor
version
plan or successor version or something like that?
accepted by town meeting. I think, doesn't the master plan get accepted by town meeting?
It does. As far as I remember, going back 20 years.
Yeah, I'm gonna make that yellow so I can verify that later. Okay, got it. That's a good catch.
I have a couple of questions.
Shoot.
Sure. Go for it.
Specifically around the buffer concerning wetland areas. It mentions not less than a 20-foot buffer.
Where are you at? Give me a number.
It's
8.3.15
Yeah.
sub 3.
I got it. So
so
that's what it is. That's what it is today. So,
right, but the Conservation Commission has a policy of no less than 25 feet. And realistically, under the Wetlands Protection Act, they can have up to 200 feet of jurisdiction. So I think 20 feet is far too small, especially since it could only go down from there. And there's also a reference to driveways necessary for access and egress to and from the track may cross the buffer areas.
I see that, yeah.
So then it's no longer a buffer. If it's paved over and you're driving over it, there's no buffer to a wetland.
Well, there may be no other way to get
Right,
across
but
it.
that-
Yeah.
I don't think that's a reasonable. I mean, we're destroying the most critical part of a wetland is the first 25 feet.
Yeah, but there is an exception under 310 CMR 10.53 for single crossings to otherwise inaccessible upland.
Right, but there are also associated performance standards.
Yeah.
And mitigating. So what mitigation is required under this? And what is if the planning board is deciding on that, what background do they have to make wetland decisions? That are going to impact wetlands?
These are all very good questions. And I think maybe what we should do is just highlight it and send it over to the Concom and ask them what they think we should do.
Okay,
Does that make sense? One of the first things you said was troublesome, and that is the Conservation Commission has a policy,
Right.
and policy is not law.
No,
There's a-
I
There's actually a
understand.
case from Andover or North Andover called Fieldcrest Meadows versus the Concom. They had a policy of a no touch, and
Right.
the builder sued and said policy is schmolicy, and he won.
Right, and the commission has had it in effect for at least 10 years, and there's always been some give and take, but there's never been an appeal. There's never been an appeal based on that policy.
Yeah, well, people want to build, they don't want to argue.
Right,
So
and there is always give and take with the
Yep.
buffers, but I think 20 feet is far too small when chances are it's going to be requested 10 feet or 12 feet, and then that's no protection.
yeah, I think let's do this in concert with the people that are, in charge of wetland areas. So let's send this over to Concom, just like it is. I'll prepare a little email, share it with Dan. Dan can forward it. And we'll say, we're doing the bylaw over. This is in there. It looks old. And we know that it's inconsistent with your policy. What would you recommend we do?
Okay. Now, what about, will there be any associated performance standards? So if someone wanted to get a variance from this bylaw, what would they need to do to overcome the standards?
I think that really has to come again in concert with the Conservation Commission.
But isn't it then partially deferring authority of this bylaw to the Conservation Commission?
Yeah, but does the Conservation Commission administer a local wetlands bylaw?
No.
Well, that's the problem. So
Well, they administer the Wetlands
probably
Protection Act.
100 towns in eastern Massachusetts have a local wetlands bylaw.
No, I understand that. But the Wetlands Protection Act is much more stringent than this bylaw. So it could be competing interests between the boards. One decides one decides the other. And then it sticks the applicant in the middle.
Yeah, I get what you're saying. My druthers would be to get this out of the zoning and let the Conservation Commission make the decision.
I agree wholeheartedly.
Yeah,
I think that would be the best course.
Yeah,
So if we were to do that, what would be the requirement? Would this need to again have rules and regulations of the Conservation Commission to be effective?
well, it would have to be pursuant to a bylaw first. So the process works by having town meeting vote a local wetlands bylaw, which is understood to fill loopholes in 310 CMR 10, which is the state regulation. And then the typical loopholes that get filled would be the state regs don't mention vernal pools, so we adopt regs for vernal pools. The no touch, is what we're talking about here, and that's not in the state regs. Those are the two principal things that the local bylaw accomplishes. And like we just finished talking about, the Conservation Commission then adopts, not town meeting, the Concom then adopts local rules and regulations to administer the bylaw. And all the details of the application process for the local wetlands permit are in the rules and regulations. And that goes back to a case called Lovequist versus Dennis from the 1970s. If any of you know Greg McGregor, who's a very prominent wetlands lawyer, that's how he made his name. He won that case at the Supreme Judicial Court. Because the developers were arguing local regulations were preempted because the state regulations filled the field. And McGregor pointed out how that's not true, and he won the case. And since then, he's made a living working with local conservation commissions. He's still kicking too.
So, and again, I'm going to ask the question. I know, Ms. Green, you've got a great feedback here, which I totally appreciate. And Mr. McGrill, you may also have an interest here, just where you've represented many people before the town's various bodies. Is this something that you would find to be consistent with consistent and workable to accomplish the town's needs as well, as well as not untenable for clients.
No, I think, I think Judy brought up good points. I think it, you know, consistency is important. On how they're looked at, so that's my comment. The history on this section of the bylaw is interesting because when it was originally enacted, it was mandatory that you had to mark under a bylaw do an OSD. And then that Westwood case came down that they said that you can't do that. And that's when the town meeting amended it to make it an option in doing a subdivision, not a mandatory requirement.
Yeah, that's the Wall Street development case.
Yeah, but I think Ms. Green made good comments on this, so that's all I have to say.
Thank you.
Okay. It's very helpful. So if Mark, if I could ask, if you can send over a draft as well of local wetlands bylaw, just so that we can try to incorporate that into the review itself.
Sure, I'm gonna send you the Mass Association of Conservation Commission's model, because they're smart. And they also have model regulations as well. So they've got a model bylaw and they've got model regulations.
Awesome.
And if you want, I'll send you Greg McGregor's phone number.
Sure. I think I'd interacted with him on another matter many years ago.
Yeah, most zoning lawyers and wetlands lawyers don't speak the same language. When I have wetland issues that are relatively complicated, I bring in a gentleman by the name of Chip Nyland. In my opinion, he's the best practicing wetlands lawyer. And you know, it's always a relief because I don't want to be dumb, and I know where I'm smart and where I'm not. So we're a good team.
Any other comments on the open space development? Oh, it sounds like we've got additional review. We've got some additional information that's going to be coming down.
Okay, I'm moving on to trailers.
Okay, moving on to trailers themselves.
This is an easy one. I didn't change anything. You might want to up the 12 months to 24 because insurance companies don't act very fast. But other than that, that's really the only comment I have.
The only thing that I noted in here is somewhere else, it may have been in the definition where there was a definition of a trailer. I think a trailer was defined as less than 27 feet.
Yeah, that's probably in your definitions.
And many trailers exceed that if they're going to actually be used.
Hang on a second, I'm looking up your old definitions. There is no definition. There's no trailer definition.
It's under recreational trailer, Mark, but I don't think,
Okay.
I don't think that's applicable to this.
No, I don't think it does either.
Okay.
That's limited to 28 feet.
Yeah, recreational trailer or vehicle, and then it goes on to a bunch of different kinds, none of which I think are, you know, a trailer moved onto the property after a fire.
And the other note that you put in here, the 12 months, that may be something that given the slow pace of development and the need for time to get plans developed along with something built, we may want to increase that. Do you have suggestions as to what other towns are doing that may be more realistic?
Everybody has this. It's sort of a really old provision. I don't know that people even do trailers anymore if their house has a fire. There's so many apartment buildings right now. Like when we rehabbed our house 5, 6 years ago and the guy went belly up and bankrupt in the middle of the job, we moved into an affordable housing complex. Not that we qualified, but they were happy to charge us a surcharge to stay for 6 months. And when the house was finally back in shape, we got out of there and came home. In fact, we really enjoyed it. It was great. So that's probably more common than going through the trouble of getting a trailer and putting it in your backyard. I can't
And-
remember the last time I heard about, somebody with a trailer while their house was repairing itself from a catastrophic event. But I do know that, in situations where a non-conforming structure has gone down, the statute says that a non-conformity that's not used or abandoned, not used being 2 years usually, but I've seen 1 year, that can be trouble with the insurance companies.
So, and I'm looking at where this was an actual issue was in Andover and Lawrence after
Oh,
after
yeah.
the explosions there
Yeah.
in 2018. And so knowing that some of those properties are still undergoing, even 5 years later, they're still undergoing repairs. I'm wondering if it makes sense if this is needed to expand it to maybe 24 months, just to allow people time to get things in place. And if we take a look the at the church that's finally being reconstructed on Main Street, that fire was, I believe it was 2019 when that occurred. And so or it was 2018 or 2019.
2018.
And so it's 5 years and it's still being built. It should be built sometime next year. So it's a 6-year process. That's more of a commercial structure, but 12 months seems very short for doing something along this line. And I can see where people may choose to do temporary displacement depending upon the type of property. Joe?
Yeah, Dan, one thought would be to reapply. You can ask people to reapply after 12 months. So maybe the building inspector can look to see what's taking so long, maybe. I don't know, just a thought.
My only thinking about that, and I'm just thinking about it from a homeowner perspective, is that if it expires in 12 months to do the application and the process to get it approved, you're going back, now you're looking at it about 7 months for the time to do that, to make sure that you have time to make other accommodations if things don't work. And that's where I'm looking, and it feels just really short. I like the idea of doing a reapplication, and maybe it's 12 months after an initial period of 18 months or 24 months.
Yeah, you could do something like that. I just, if sometimes people sit on things, if they don't have a fire under their ass, they sometimes don't move. And if you give somebody too much time, then construction sometimes gets delayed also. So just a thought.
Okay,
Mark,
well,
is that something that could be put in where the initial period is, maybe 18 months and then it's annually thereafter? They can apply for an annual permit.
so you want to bump the original 12 months here to 18 months?
I'm thinking that would make more sense. And while the family that's moving into what's affectionately known as the mansion, that project is going to take about 3 years to complete from when it started. And I think about if someone had to go through that process, they might need to re-up it, which would be fine. But again, to Joe's point, we don't want to give too much time either. So we want to make sure that that conversation is happening.
Yeah, yeah.
So I think that having the trauma of the initial event, whether it's a fire or a natural event, that would make it there. The other piece of this is if we can possibly change the word Holocaust, that just doesn't quite strike me as an appropriate word to use. If we can choose another word in that possibility.
Yeah. I like catastrophe.
Because if there is if there's a large catastrophe, whether it's from a major snowstorm or a hurricane, something along those lines, and someone is doing this, it's going to take time for that to go through. That's where I'm just thinking 18 months, and then, you know, the additional permits can be secured for 12 months thereafter.
Why don't we just say that this period may be extended by the building commissioner for good cause? Do you still call your guy the inspector of buildings? What do you,
Yeah.
Building inspector,
building inspector or building commissioner?
building inspector.
Okay, I always call them commissioner unless they call me off. Because they earn the title.
Some towns are different, Mark, like you said.
Okay.
but
So
yeah,
this period may be extended by the building commissioner for good cause, building inspector for good cause. That work?
I'm thinking up to 12 months at a time or something like that, just so that it's not an open-ended extension.
Okay, so 12 months, not 18, while the residence is being rebuilt, this period may be extended by the building inspector for good cause.
Well, I'm thinking initially 18 months, it may be extended for up to 12 months at a time with good cause. So
Okay,
that way it gives the building inspector direction that the building inspector can unilaterally approve an extension, but not a 3-year extension at a time. It puts some boundaries on it.
yeah, this period may be extended by 12 months by the building inspector for good cause.
Does that thoughts from other members?
I like that. I think that makes sense.
Okay. All right, I'm gonna put that one to bed.
Okay.
And the next one I picked out was MBROD, the Municipal Building Reuse Overlay District.
And that is in the process of being shared. There we go.
And I don't think I changed anything here. And I'm verifying that I did not. I just renumbered it. And there's a little glitch in 929. But that just needs to get erased, that's all.
Oh, you mean the C?
Yeah, I just took that out because I captioned the next thing special permit, so.
Got it. There's also a space missing in 922.
Yeah. I fixed that, yeah. So I assume this is what you use to, you know, a lot of old schools have been converted into HUD 202s for people over the age of 62.
I know we have done that in the town, although I don't think we've done it recently.
This was used for the Franklin School, Mr. Chair.
I think that was the last one that was used for, correct?
I think it might be the only one it was used for. But it was successful.
It was.
Yeah. Was it affordable?
No,
No?
no. I think
Okay.
that
Still not.
it was a different time, frame when that, and I think I think at that point, the town wanted to get as much money for the sale as they could.
Oh, I see, okay. Well, that's interesting because,
It was a while ago.
so the last case of spot zoning I know of was Somerville had a municipally owned parcel and they downzoned it so that you could do more stuff there, and then they sold it for a higher value. And the decision of the city council got reversed because the benefit was, was not what you would normally call a public benefit, even though they made more money off of it. But I think Judge Long And the land court threw it out.
That's interesting.
Any other thoughts on municipal building reuse overlay? Otherwise, just administrative changes.
I'm on to creative. Just make sure I don't have it out already.
This one has a few more changes.
Yeah, I gotta go on my, hang on a second. New creative. Okay. All right. So you can see that this is an overlay district. It didn't say that before. And I picked up that it's an overlay district in 932. All of a sudden, it's an overlay district. So that's fine. And I put the standard language in 931, superimposed over underlying districts as shown on the map. You need a map. All districts have to have a map. And I don't, it's not, unless it's town-wide, and I don't think it is.
For those of you on the planning board, are you aware?
Yeah, I'm looking at the map. We'll come back to that.
So that kind of makes it go to a different chapter. Normally, if it was a thing, it would have been in, you know, a chapter with things in it. This is a special district now. It's an overlay district. So there's a whole chapter of special overlay districts. And that'll include floodplain, and you've got a couple, the municipal building reuse overlay district. All the special districts go together, and usually I put them in chapter 9. Some strikeouts in 9361. I don't know that the Take the T and Zipcar home mortgage program is still available, but I think what you're looking for there is affordable dwelling units affordable dwelling unit commitments. I don't think that program exists anymore.
But there are other ride share or other things like that, right?
Yeah, I'm not aware of that. That's out of my wheelhouse.
Yeah.
I used to play racquetball for 25 years with a guy who worked at the T right across the street in Boston, but that's as far as he retired early. So that's 9361. I'll try to find something out on this.
I don't think we have an overlay map that's on our website.
Yeah, because I don't think it was understood to be an overlay, but it is an overlay.
Yeah.
So what is this? What is it? The number of parking spaces shall be as required. Number of required spaces may be reduced to reflect demand reduction commitments agreed to by the developer and enforceable by the town. Well, this is now called a transportation management plan. And it's pretty standard in a big project that the developer would propose traffic demand management steps like bicycle racks, like showers in the building for people who ride their bikes to work, by handing out tea tokens by this, usually a list of 6 or 7. So let me get the language for that and substitute it. It's part of special permits for large buildings in an environment where there's public transportation.
Will this be impacted by the MBTA, the adoption of the MBTA
No,
components?
this is just about talking about the number of parking spaces. That's all. So
Okay,
you can reduce them if, the typical reduction of parking spaces would come if you can show that rather than everybody in the complex having 2 cars in a unit, there has been some incentive to move them onto public transportation and or provide amenities that would assist them in not using their cars. And so I'll talk. I was just on the phone with Bob Michaud, who's my steadiest transportation engineer, and I'll ask him to suggest some language here.
okay.
Yep.
Because I think that the key to this being non-controversial is the language that talks about demand reduction.
Yeah.
Just in this town, anything to do with parking tends to be a third rail, a proverbial third rail.
Yeah.
So if we're going to have something that allows for an exception from a standard amount of parking, which I'm not opposed to, we just want to make sure the reason, the rationale, the componentry of it is explicitly mentioned as well.
Yeah, I think what it's going to end up saying is that the applicant may ask the planning board for a reduction in the amount of parking that are otherwise required by section 6.1 upon approval of a traffic, I think it's called a TMD, TDM, traffic demand management plan. Let me look up.
So along those lines, should this go before the planning board or should this go before the Board of Appeals?
No, I think it should go to the planning board. You don't want a variance for a reduction in parking because you can't pass the soil condition shape topography test. What you're really saying is that if it's good enough and it'll help out by not having as much asphalt, then we'll give you a special permit to let you off the hook. And I think there might be a reference, just to remember that there might be a reference in the performance section under the traffic provisions. Yeah, there they are, right there. The proposed development and redevelopment of the parking will be forecast. And there's a section in here, transportation plan approval. And it kicks in for people for a project of bigger than 25,000 square feet with a traffic management component. And the elements of that this is in the performance file that you have. And it's under 6.4.7 and then 6.4.7.5, and you'll see D. And here's the thing, here's the things that are usually a part of a traffic management component, part of a traffic plan. And this is all standard language now because it's in the ITE guidance documents, and those are the same as the DOT guidance documents for a traffic impact access study. So you look at there's like 6 things there: carpools, van pools, rail passes, monetary incentives, shower facilities, blah, blah, blah.
So given that most special permits, if not all, have been issued by the Board of Appeals,
Yeah.
as opposed to the planning board, I'm just trying to figure out if this is going to change the way the process if someone is using this creative overlay district, which sounds like it for right now is the entire town.
Until proven otherwise.
So is that something that the planning board would expect to take on? So for those of you who are also on the planning board, interested in your take, because again, you know what the different pieces are. I'm quite confident the ZBA would have no problems delegating something controversial to someone else. They get enough projects to manage. They're not short on work.
Well, this is a good place to talk about the parking provision as well. So in the parking section, probably the only change I made is a paragraph at the very end. If you want to go to the parking and loading section.
In the performance standards?
No, in the parking file. I think it's called park load. So we're talking about
6.1, got it.
we're talking about competing special permit provisions. And what I always put in my parking standards is something that says, if you don't like this, I think you might have already had it. Yeah, I think you had it already.
And part of what I'm just asking about is the division of approval cycles. So it's very clear as to which body has to approve various projects.
Yeah.
Because right now, pretty much
Right now,
everything goes to the Board of Appeals.
yeah, and there is a
DBA.
parking exceptions for the business district, 6.1.6 in the parking, where the literal application of the standards, parking and loading prove infeasible in the business or municipal districts, the ZBA may reduce the requirements by issue of a special permit. And I had a comment in the margin. I recommend that you create a generic special permit to allow for deviations from any and all parking requirements. And if that's the case, then this is probably redundant.
Mr. McGrail?
Yeah, I just wanted to go back for a minute on the creative development.
Yep.
So, I'm aging myself out here, but I've got some feedback on this for you because I actually went to the hearings back in 2004 when this was developed and enacted, the planning board hearings. And Mark is 100% right, and so is Theo. There is no creative development overlay district because the way that bylaw was designed is you would pick a site, and I don't even know if this is legal, Mark. I'm just telling you the way it was designed.
Yeah.
Would pick a site, and you would propose a development on that site, and that at that town meeting, that's when that overlay district would be created. So they call it a creative development, and then anticipate the creation of the overlay district with a site.
Okay, so that's very similar to what I would call, and I have done this in larger communities, especially a planned development district.
Yes.
And a planned development district is a bright idea that somebody has that's not in the book. So the best example I know of a planned development district is the intergenerational campus in Dedham, overlooking the Charles River on 100 acres, housing the Rashi School, K-8, an assisted living facility, a long-term care facility. That's a nursing home. It also has a child care center and about 90 acres of open space. And who in America has that in their book? But the town loved the idea. The developer wrote it up as a bylaw, and it's now in the Dedham zoning bylaw as, I don't know what they call it, but we always called it the intergenerational campus. And there's many other examples of really great projects that are just not in the book. And I like the name, creative development. In one town, I called it an innovation district. So we're all speaking the same language. And it's not in the book. You come to town, you go into the manager's office and you say, I got an idea. And if the manager says, yeah, let's get the planning board in here, we'll talk about it too. And then you go another step and another step and another step, and then you write it up and put it in front of the voters. And it's really zoning for a specific piece of property. It's not, there's no real fear of spot zoning anymore, because spot zoning has more or less been invalidated by the courts as a doctrine. It used to be that you'd look at all these factors for spot zoning, the size of the parcel, but now the only question that really is pertinent is whether or not it serves a public benefit.
Yeah, so the way that bylaw works is as Mark said, you find a piece of land, you
Yep.
go to the planning board and say, I want to develop this. You work with the planning board, you take it together before town meeting. You've made a commitment on what you're gonna do with that land. And then you get that site part of the creative development overlay district for that purpose that you've committed to. And then if town meeting approves it, there's no special permit process, so it isn't Board of Appeals. Because what it says is you go on, it talks about the town meeting process. The planning board's recommendation to town meeting shall include its observations. And then it says, following town meeting approval for the creation of a creative development overlay district in its accompanying concept plan, permit applications relying upon that plan should require site plan review by the planning board. Planning board shall approve such site plan provided is consistent with the concept plan. So when Paul Rivas designed this, no developer is going to want to spend all the money to go to a town meeting and spend all that money beforehand to get a vote and then be subject to a special permit process that could be
Right.
appealed. So that's why it's only a site plan review before the planning board once you're done. And this is jurisdictional totally to the planning board, not the zoning board of appeals. And I'll tell you this,
Yeah.
it's been on our bylaw since 2004. It's never been used before.
But it's very valuable.
I agree. I'm just telling you.
If you drive 128 past the mall in Burlington, well, first of all, Burlington does this all the time. But if you drive them past the mall, past the 4225 exit, you're parallel to Hartwell Avenue on the west side of 128. All of those buildings there, which are in Lexington, are individual planned development districts because they all wanted something that wasn't in the bylaw. And I think when I recodified Lexington, they had 26 planned development districts. And I love the idea. I think it's very innovative, and it invites creativity, which is why you have it called creative district.
So given the discussion we've just had, does it need to then be stated as an overlay district?
No, I think we've now discovered the true origins of this, and I don't consider it to be an overlay district. What I consider it to be is a district in waiting.
Yes.
And they're all going to be different. So literally, Lexington has PDD 1, PDD 2. I just put this into Haverhill a couple of years ago. They're on PDD 3 already, and in 2 years they're on PDD 3. The first one was a banquet hall from an old family that ran it for 50 years, and then they wanted out, so they sold it to Princeton Properties, and Princeton Properties is putting a couple of hundred units in there with a Starbucks.
Mark, the guy who the consultant the town hired was somebody by the name of Phil. I can't think of his last name, but he did.
Hare.
Who was it?
Hare.
Yes, thank you. That's exactly who wrote this, Mark.
He was my mentor many years ago. I took classes with him at MIT when I was in law school.
This was his bylaw.
Yeah, this is Phil's work. I can see it.
Okay, so that's really helpful. It sounds like there's some language here that may need to be tweaked a little bit again, just to get rid of the word overlay, since
Yeah,
it's not.
I can do is now that I know it really wants to be my PDD, I won't change it to PDD. I'll work with the title of Creative Development District. And I'll make it, an invitation to people to come forward with a bright idea.
Theo, do you have comments?
No, that's good. wanting to know, yeah, how we are ending up. That totally makes sense.
But the one thing that we didn't finish talking about is this whole concept of reduction in parking spaces. So let's go back to that for a second. This has a special provision that talks about reduction in parking spaces. The performance standard section that I referred you to has a requirement that you do a transportation management component in a big project. And the parking section has a reduction in parking spaces available for the industrial and the municipal district. And I want you to think about having a generic parking special permit that would allow anybody to get out of something that they don't want to do without the need for a variance upon a showing to you, you meaning the special permit granting authority, whether it's the planning board or the ZBA, that there's not going to be detriment as a result, and it's all going to end up fine. And obviously that comes with a parking consultant in some cases, with a transportation engineer, traffic engineer in every case. You don't just hand these things out like candy. You got one side heavily armed with their own consultant, and you're peer reviewing it with yours. And only if the two experts agree that there's no detriment to be caused here, do you give them the special permit for the relief. Because otherwise, if you know, we're fast approaching December 10th, which is what the Burlington Mall was designed for. And on no other day is it designed for that.
My concern here, seeing a lot of silence on the screen. My concern here, I suspect others may be thinking something along these lines, is that parking is such a challenging issue. Expanding the exceptions may encourage a further increase in density where it's not otherwise specifically handled with the associated bylaws, so that we have issues with parking if people are converting single family to 2-family, 3-family, 4-family, and they can show a showing of, if it requires that they show that there is ample parking, which puts a lot more pressure on the special permit granting authority to then have a separate peer review of any information that's brought before them. And to do that for certain districts, I don't see as being a problem, but I see that otherwise increasing the workload for the special permit granting authority by basically increasing the allowable exceptions without any sort of other exception. And part of that is I'm trying to avoid a greater discussion of parking, knowing that it's a third rail for the town itself. That's just my 2 cents. Others thoughts on this?
Yeah, I agree with you, Dan.
Okay, well then I think I can piece together what you've got now in the business and municipal districts, the requirement for a parking management or a transportation management component, which would include things like reductions in parking for doing good things, right? The ride share kind of stuff. And I think that's probably the safest way to go. When I did New Bedford many years ago, in the middle of the recodification, Compass Bank came to New Bedford, went to the mayor and said, we want to open our headquarters downtown. How big's the building? I can't remember, a couple of 100,000 square feet. When you ran that through the table, they needed something like 700 parking spaces. So you can't get a variance for that. It's not a soil condition, shape, or topographical constraint. It's just a lot of space that you're going to eat up with parking that you might use 10 days a year. So we put a provision in that you could reduce the parking if you had a good reason and you made a compelling case. You want a bank or you want a parking lot? So something to think about, that's all.
Okay, yeah, and part of this is I'm trying to avoid things that I see, like the marijuana piece. We're breaking that out separately. I'm trying to avoid things that will get people buried in the weeds where we can avoid it. And the parking just happens to be one. There have been two recent issues where parking came up before the town council, our administrative group, and it caused an immense amount of division and many hours of conversation that ultimately decisions that are made now are not binding on the future anyways.
Okay. All right, mindful of the time, the last easy one I had was accessory.
Any other comments on on open space development before we go forward? Welcome to Wakefield, where what you may think is easy is all relative. So what was the other one that you wanted to go over?
There's a section that I had called new ACC uses, ACC dot uses, accessory uses. And I don't think I changed much here. I'm going to add that accessory scientific provision that we talked about last week or 2 weeks ago as something that you can do in a residential setting. I've just copied your agricultural accessory uses, business accessory uses, and industrial accessory uses. And I've put in a placeholder for the home occupation, which we haven't discussed yet. And I've taken your accessory apartments and added it here without changing them. And the art craft studio as well without changing it.
So there's two pieces to this. The general accessory uses, this is the general one. Just because it didn't have a number on it, so
Right. And the next one is 332. So in general, a residential accessory use is either in the use table or, and this is the land court speaking in a case, it's actually the marijuana case from Charlton. Other accessory uses are allowed, even if they're not listed, provided they meet the definition of accessory use, and then I'm quoting the definition there. And Judge Foster wrote that decision. I argued on behalf of the town that, like principal uses, if it wasn't listed, you couldn't do it. And there was nothing in their bylaw that said you could have manufacturing and processing accessory to a cannabis grow facility. And he said, well, there's nothing that says you can't either. So he kind of stood the rule on its ear and said that you can't imagine all accessory uses, so therefore you have to have some leeway. And later I used it against him in another case. So it's fine with me. I actually had a gentleman in Boxford who had a 3,500 square foot house. He wanted to build a 1,000 square foot accessory structure, and in it, he wanted to make 1/8 scale model working locomotives. He had the blueprints for these famous engines from the Pacific lines. And he made the first one with his father. His father died. He was in his 80s. He was on the second one. And the neighbors thought he was a machine shop. But he didn't make any noise. And he didn't bother people. He didn't sell any parts. He didn't give kids rides. He just had a unique hobby. And we won.
Joe.
Yeah, so Mark, we've been seeing this a lot on the ZBA. So under F, your thoughts on the accessory apartment shall not involve an extension or enlargement.
Yeah.
So the way around that is you build an addition, you wait a couple months or a year, and you come back.
Yeah.
So we've kind of been just like approving it with the addition the last couple times.
Yeah, you could do a look back, say 5 years. When the application comes, we're going to do a look back. If the house has been expanded, we're going to make you wait 5 years to do it.
Joe, I think you want to allow the addition, right?
Yeah, I mean, to me, I'm fine with it. I'm fine with them doing, because we've been allowing with the addition to do, just like, Because Brian's gonna come to us with the adjustment, instead of going around it, he just comes out blank, plain blank and say, hey, we're putting the addition on.
Yeah.
And, so, I mean, have you been seeing that at all? Do you have thoughts of
Well, I think
against it
everybody,
or?
everybody that looks at this has the same discussion. Are we gonna allow this in the existing structure? Suppose somebody's building a brand new structure. Can they, from the get-go, put an accessory apartment in it? I mean, this is the governor's housing bill doesn't have anything like this, but it has some thought about accessory apartments, and I don't know, I don't think yours allows it in a secondary building, does it?
No,
Yeah, that's another debate everybody always has. Can we put this over the garage if it's a freestanding garage?
right up above Mark, it says an accessory apartment must be located in the principal.
Yeah, I'm looking at it, yeah. So I would ask you the same question. Do you want to, why would you let a room over the garage go to waste?
I know, so I'm thinking, do we just get rid of this, or is that gonna invite more? I mean, as of now, we've been doing it anyway, so. Do we want to take that out, or should we leave it, in there and leave it to the discretion of the board?
Well, why don't I show you an accessory apartment? Well, there's two things. When the governor did the housing bill coming up on 2 years ago now, there's a provision in it that talks about accessory dwelling units. They're called ADUs. And he's got rules for ADUs. They can't be bigger than 900 square feet or I think it's 50% of the total GFA of the structure, whichever is smaller. So it's never going to be terribly big, which is sort of consistent with yours. It has to have owner occupancy in one of the two units. It doesn't have to be family, and I don't see you don't require there to be kin relations between the tenant.
Yeah, we do.
I think we do.
You
Do
do.
Mark. Yeah, if
think
you
we do,
scroll up,
yeah.
Mark, you'll see it.
Yeah, I'm scrolling down. Oh, yeah, I don't like the family ones. I mean, that's a mother-in-law, right?
See right there, Mark, occupancy, owner occupancy required.
That's fine.
No, but
But-
keep going. Reading that paragraph.
Yeah, the question is whether or not, so in a typical situation, the owner occupies the principal residence. And then he rents the accessory apartment. And some towns say you've got to rent the accessory apartments to a relative. And that's why they're called mother-in-law apartments. And other towns don't care who you rent it to because people need housing. So as long as the owner is an occupant of either the accessory apartment or the principal residence, because why wouldn't a single older person move into a small 600 square foot accessory apartment and get the money for renting out the other 3,200 feet in the house?
So you think we should get rid of the family member occupying the accessory apartment? Is that,
I'm not seeing it. I see owner occupancy.
it's like the
required.
fourth line in that sentence.
Which section are you in?
This
Right up.
is section F.
Third paragraph, 4 lines down, surviving parent or family member occupying the accessory apartment,
Yeah.
right there. Oh, is that it?
Yeah, that's it. It's always
Yeah.
been, this bylaw has always been interpreted, Mark, that it has to be family, all family members, because it says a family member occupying the accessory apartment.
Oh, I see. That's a pretty slim read.
Yeah, it's the way it's been.
Well, I mean, my personal opinion about that is that, if it is a mother-in-law apartment and, your mother-in-law is 88, are you really going to put $25,000 into reconstructing the house for?
Yeah, people do it, but it's an
Then
ancient,
then you have to shut it down
it's an
if you can't
ancient,
find another family member to move in there.
yeah, it's an ancient bylaw, Mark. I mean, it's,
Yeah.
This is one of those situations where I think as a committee, and I'm hearing this from different people, that we may want to remove the family connection, the family requirement, and just knowing how families work, you may not necessarily, you may be more comfortable with a stranger than your in-laws there anyways.
That's a nice thought on Thanksgiving week.
Point well taken.
On Thanksgiving week, I think it's as if not more appropriate than any other week.
All right.
So I think to remove the family requirement, as well as also removing the fact that it can only be in the primary structure. So what I'm looking at here is this will increase the ability to have accessory apartments, which will achieve one of the goals that I've been hearing repeatedly, which is to have more housing available. And
Yeah,
that,
that's why
that increases the housing, the ability to have housing stock without actually increasing the density of the facilities themselves.
Yeah. So that would mean amending 3.8.2 in my version, and maybe created either within a single family dwelling or a standalone accessory building also on the premises. And then you would also want to amend 3.8.3 to say the owners of the principal residence shall occupy at least one of the dwelling units on the premises. That's consistent.
Right.
And you just delete that reference there to the death or removal of the surviving parent or family member occupying the accessory apartment. You could put the special permit on a time limit, not the death, but you could say it's 5 years. And, every 5 years, we want you to come in and give an affidavit to the special permit granting authority that you, as the owner, are still in residence in one of the 2 units on the property. That's a pretty common feature.
Mark, would it run with the land?
Yeah, but only for 5 years.
Okay.
So even if the property was transferred, it would still, you could say transfer or 5 years, whichever comes first.
That would probably make more sense.
Yeah.
Mark, there's another provision too, if you could scroll down. This makes no sense to me as long as you're looking at this. Where is it, Joe? It's something about, keep going. Hold on a second. Let me see. Where is this? Where's the lot width, Joe? There's something in there. Go back higher, Mark, if you don't mind, at the beginning of the bylaw, because this makes no sense.
Okay, I'm making a note to myself. So hang on a second.
Oh, right there. The accessory apartments may be created only within single family. Okay. Located on lots meeting the minimum lot area and width requirements. I mean,
Yeah.
that just makes. And the problem in Wakefield is most of the lots in Wakefield are non-conforming. So we have to usually when I do these, I've got to apply for a variance from that requirement.
Oh, so you can't even build it on a non-conforming lot
You got
without
it.
a variance.
You got it.
Oh, brother.
I wanted to point that out to you,
Yeah, good.
Joe, because that's another problem.
Yeah, because that's always on your list. When you come
Well,
to
I mean, if it's a special permit and you don't meet the minimum lot area and width requirements, you might not have very good luck, but at least there's a control mechanism in place.
Yes. Yeah. I just want to bring that to your attention.
All right, I'll play with that too.
Because I view the idea of accessory apartments as an area where we can really make substantive positive change with minimal detrimental impact on the town. And while this is a policy, this would be a policy change. I think that if the committee agrees that this makes sense, this is really a big part of the reason why we review bylaws periodically.
Yeah, there was an article done long time ago on the benefits to towns from inclusionary zoning. This is inclusionary zoning. And I think that the statistic was appallingly low, that the total number of affordable dwelling units created using accessory apartments was like 1 or 2%. So, and I was somewhat, puzzled as to why the governor put so much attention on ADUs when everybody knows that the big deal is apartments. I mean, apartment buildings with hundreds of units in them. That's what we need. Attics being converted into small single family or single apartments is not going to answer the housing crisis here.
Real quick, I had a question on that. So earlier we brought up in-law apartment, which you would not normally charge rent for an in-law, or maybe you would. That now if
Depends,
this is not
depends
an
on the in-law.
what's that?
Depends on the in-law. You might
Yeah,
want to
exactly.
double it.
So now, if it's not an in-law and you are charging rent, does that change anything? And does that go
No.
towards our housing stock in a way? I mean, does that matter at this point, or?
No, I mean, to count as an affordable unit under the subsidized housing inventory, it has to meet the two basic requirements of Chapter 40B, which is the comprehensive permit statute, and that is that the housing is supervised by a subsidizing agency. That wouldn't be the case, and it has to meet income eligibility guidelines, and it may or may not meet that. But they wouldn't count. These units would not count under the SHI. Everybody's trying to get to 10%. The SHI is where you can look up where you are.
Yeah, exactly. I guess that's where I was heading.
And
Mr. McGrail.
you just put in DHCD space SHI and you can see where you are. The latest one was from June of this year.
So I just want to point out, if I may, Mr. Chair, I'm all for this. I think I'm all for it. But just like the parking thing, just to put your attention on this, I think it could be something that will be a controversial thing at town meeting potentially. And one of the things that I think needs to be thought about is, and I might be wrong on this, Mark, but I'm pretty sure I'm right, is that if these units are created and they can be rented out to non-family members, they're going to count as part of the fair market value housing stock in the town. So they're actually going to hurt your goal to get to the 10% SHI number with DHCD. So it can work again.
You're probably right.
Yeah, so if a bunch of these come in, and you're over 10%, it could drag you back below it again. Because now they're not restricted to family members. I'm not 100% sure of that, but I'm pretty sure. And I just wanted to put that.
Because the denominator on the SHI is year-round dwelling units. It doesn't distinguish between year-round principal and year-round accessory.
So I'm all for this, but it might be one of these things, Mr. Chair, you want to kind of put on the side and not part of the, similar to what you're talking about with another one that might.
Yeah, I've already made that note to myself. So.
With the marijuana thing, because I think it'd be an interesting debate at town meeting on this.
All right, well, let's end on that theme tonight, because I've got kids that are visiting. They came today. I've got 3 children and they all live far away and they're coming in for Thanksgiving. So it's, I'd like to get back with them, but let me just give you one more that we probably want to put as a separate article, and that's adult.
Okay, and just real quick, I just want to share it just so that I think this will only take about 20 seconds or so, which was the scientific accessory uses.
Yes.
We briefly discussed that last time. Is that also going to be incorporated into the accessory uses?
Yes, there was a placeholder for it back under residential.
Okay, just wanted to make sure we had that as well. And then last one was adult.
Yeah, so the adult uses are the things that I scratched out, and that will be a defined term, and all of those things will be in the definition. So we're just, some places call them adult entertainment facilities or adult entertainment uses. Adult uses, call it what you want, it's all the same. The key to the yellow in my markup here is that adult uses are protected under the First Amendment, and the Supreme Court of the United States first decided that back in the early 1970s. There were a couple of cases. There's a couple of models for regulations of adult uses. One is concentrate them in the combat zone, and that's some cities choose to do that. And the other one is spread them out as far as you can so that they can't be within 1,000 feet of each other. Yours tends to be in the second camp. And then there's a third type of regulation which addresses the actual nudity itself. So there was an article, there was a case from Erie, Pennsylvania in the early 2000s in which the city imposed costume devices. I'm being very euphemistic here because that's the term, that partially camouflaged the nudity. And the question was, because naked expression is protected under the First Amendment, how naked can you be, or how not naked can you be before your rights have been lost? The Erie case was from Pennsylvania, and we had a similar case in Massachusetts called Mendoza versus Licensing Commission. It's a Fall River case, and our Supreme Judicial Court said in the nudity cases that no costume devices could be imposed by municipalities. You have to be, if you're going to exercise your free speech here, you got to be naked. And the Pennsylvania Supreme Court agreed, the Alaska Supreme Court agreed, and one other Supreme Court, I think it's Kansas, agreed. So that's already been decided here. The other cases, the kind that spaces them out or gathers them together, you can't just regulate the adult use because you're going after the speech. And in order to regulate speech under the First Amendment, you have to show a compelling government reason, and there isn't one. I'm just repeating the holding of the Supreme Court. So the trick is that you have to regulate secondary effects. That's completely permissible by time, place, and manner restrictions. And you're not regulating the speech. Read the first paragraph. You're regulating the secondary effects. They are increased crime, adverse impacts to public health, business climate, adverse impacts on property values, adverse impacts on the quality of life. That's all fair game because none of those things are constitutionally protected. And that's the way you regulate. And it's a standard model. This is standard language. It's in, it's in everybody's bylaw. If yours starts with 744, right? May not be located. Well, you're saying you can't what you're saying there is, we're not worried about the secondary effects. We're worried about you speaking too loudly and too naked within 1,000 feet of each other. And that's impermissible under the Constitution. So it looks like a change, but it's not really a change. It's what will make your bylaw legal or constitutional. And then the rest of the stuff, is what you have already. There are provisions in Chapter 9A that talk about sworn statements. Nobody can be in the place if they've been convicted of violating 119 or 272. I looked up those statutes once, and it was like morality and children. So you're just coming into the fold here of constitutionality with that language in 742 and 743 numbered wrong.
And we will let you make that presentation on this section at town meeting.
Yeah, I've done it before, Dan. Yeah. There's no way that you don't look like a pervert making that presentation. So, whatever. That's why I get the big bucks.
Any comments, questions, thoughts?
Good.
Otherwise, these changes look like they're changing what is probably not an enforceable bylaw to make it enforceable.
Well, you don't want to mess with this industry, I can tell you that, because they have lawyers that do nothing but First Amendment cases for adult uses, and they are buzzsaws. Revere, just ask Revere. Revere tried to do a adult use bylaw, and the only place, I think the building had to be 200 feet from the property lines on all sides. There was one place in the swamp going up to Cappy's Liquors that met the objective, and Revere ended up paying a large sum of money, not quite $1 million, but over $500,000. T&D Video was the adult business. Have I scared you enough now?
Okay.
Okay.
Any other discussion on any of the bylaws. We've got still performance standards in depth, affordability, parking and loading. We will defer to the next meeting.
Yeah, and let's start with the performance standards. And it would, because this is all new material, everybody needs to read it and everybody needs to jot down questions. Because this is a whole different approach. What you're going to be telling businesses is these are objective standards that you have to meet. And they deal with noise, lights, site preparation, traffic, utility connections. It's not just minimize this or maximize that. It's do this.
So instructions to the committee itself, you've got 2 weeks. Which brings us to the upcoming date. Next meeting will be Monday, December 4th, 7 p.m. We will, at that meeting, figure out when, unless people know offhand, when they would like to meet for another time. The other meeting that would be natural in December would be December 18th, which would be the third Monday. And the idea is to get another meeting in before Mark goes off to very cold area in Antarctica. So
I had to tell that to the judge the other day trying to schedule a pretrial conference.
Yeah,
So-
nothing.
Luckily it was Judge Foster, and he's amused by my travel habits. So
No
So-
sub meetings you know of before then, right, Dan? That you haven't.
we don't currently have any of the smaller meetings scheduled. I'll work on work to try to wrangle the smaller group as well before then.
All right,
So
yeah.
I've been thinking about that, Dan, and I'll have a conversation with you off camera about the benefit of the small group, because I'm really at a point, once we have a couple more of these meetings, where I can assemble the bylaw and it'll look like its framework will ultimately end up, section 1 through 11. And I'm thinking that the small group, might want to deal with section 1, put it to bed. Deal with section 2, put it to bed. Deal with section 3, put it to bed. And some sections are obviously a lot more weighty than other sections, but that's probably a really good way rather than hopscotching around.
Okay.
But we'll talk about it between ourselves on the phone.
So Monday, December 18th, our members available for that? I'm seeing a lot of head nods. Okay, so we're going to set up Monday, December. Mark, are you available on December 18th?
I am today, but knowing, my 38 years of being a lawyer and the week before Christmas, I don't expect to have anything come on board. I know the 19th, I've got 3 meetings that want to happen already. So I'm just praying that nothing happens on the 18th. As of today, I can say yes. So.
Okay, so we're reserving you on the 18th, and that because we're not going to meet on January 1st. We're going to be celebrating the fact that this year is done and a new one is beginning.
Yeah. Well, again, I'm suggesting that maybe in January, if we could do, today is what, Tuesday? If we could do the 2nd, that'd be great, because I come back on February 3rd, so I wouldn't miss you that much.
So we may not have a meeting in January.
Okay.
We'll determine that at the December 18th meeting.
Okay.
Or at the December 4th meeting. If people, and part of the reason is I know there's some other conflicts on Tuesdays that tend to happen.
Okay.
And we have to take a look at when the town council is going to have their meetings and so forth as well, because they're going to be impacted by some other scheduling issues that come up as well. So we may go from December straight to February.
Okay, that's fair enough.
So holidays, as hopefully everyone is aware of, Thursday is Thanksgiving, otherwise known as the turkey holiday. Don't forget that Wakefield is hosting the annual the annual football game with Melrose, and fully confident that Wakefield will have a fantastic showing. They've actually been doing really well this year. So if you don't have an activity for Thursday morning, feel free to come. Mark, if you want to come with family and watch a high school football game, that's always a lot of fun between two teams that like each other off the field, but don't like each other on the field. It's always a fun adventure. Same thing with the fans.
I have a feeling that will be.
You may be
I'm the cook, so I don't have time to do that.
so you will otherwise be foul inclined. Got it.
I've got 17 people coming, and that's down from last year, so.
So Hanukkah starts the evening of December 7th. Christmas is, of course, December 25th. Kwanzaa is December 26th. So some of the upcoming holidays, we've got lots of different things coming up on schedule itself. We will have 2 meetings before the end of the year. Anything else from anyone?
Everybody have a great holiday.
Sounds good. With that, do we have a motion to adjourn?
So moved.
Kevin is the quick one on making the motion to adjourn. Do we have a second?
Second.
Tim is seconding it. Thank you very much. So with that, we'll do a final roll call vote in the order in which you appear on my screen. Joe,
Yes.
Tim,
Yes.
Kevin,
Yes.
Catherine.
Yes.
Eric. That's an affirmative. Lucy.
Yeah.
And I vote in the affirmative. So with that, we have all members voting in the affirmative. Meeting will be adjourned at 8:52.